Hello, everyone. Welcome back to Legally Speaking with Rest the Case. If you're a business owner, entrepreneur, or even a freelancer, you know that getting paid on time is crucial. But what happens when payments are delayed, or worse, never came through? Today, we're diving into an essential topic: recovery in commercial matters in India. To break it down, we have Advocate Peeyush Ranjan, who is a seasoned lawyer with 10 years of experience practicing in the Delhi High Court. He specializes in civil and commercial law, family law, property law, inheritance law, contract law, arbitration, and Negotiable Instruments Act. Today, he'll help us navigate the legal landscapes of recovery in commercial matters and the best legal strategies for business. So, if you've ever struggled with unpaid invoices or want to safeguard your business from financial disputes, this episode is for you. To begin with, Advocate Piyush, could you provide us an overview of the legal framework governing the recovery of dues in commercial matters in India?
Yeah, so Commercial Courts Act, which was enacted in 2015, represents a significant uh, shift in the Indian legal landscape. So it aims actually to provide a mechanism for the resolution of the contractual disputes. And since our Indian legal system has been criticized for delay in dispute resolution, in dispute mechanism due to overburdening of the cases. Therefore, this uh, uh, particular statute was brought by central government in 2015 uh, to ease of doing business and attract more investment in Indian market. So, in this context, it was felt a dedicated commercial law for to expedite the adjudication process. So, this act was enacted primarily with the objective of streamlining the adjudication process of commercial disputes in India, which also provides a time bound adjudication of the disputes and equipped with necessary expertise and uh, and not to unduly hamper the prolonged litigation. So this is for the businesses who are all doing on the large scale. And so far as small enterprises are concerned, MSME Act was introduced in 2006. That is, yeah. So far as small enterprises are concerned, the government came up with a legislation which is Micro, Small, Medium Enterprises Development Act, which was brought in 2006 with an objective for development and regulation of small enterprises engaged mostly in the business of manufacturing, processing, and providing services. But this act also provides for the dispute resolution mechanism. So basically, what happened with small enterprises is the delay in payment. So this act came up with a dispute resolution which provides a conciliation between the parties and a conciliation center is. Uh, am I audible?
Yeah, you're right.
Yeah. So this mechanism provides facilitation center around the India. So the basically it start with conciliation proceeding, because what happens after receiving goods or availing services, most of the parties deny payment on one pretext or another. So to resolve the delay in payment, conciliation center is constituted in India, which is called MSME FC, MSME Facilitation Center, which start with conciliation between the parties. If the conciliation is failed, then the matter is sent back for arbitration. Thereafter, after the arbitration proceeding is completed, award is passed. And most interestingly, the defaulting party is liable to pay the compound interest.
Okay.
In rest of the cases, party is liable to pay the amount with simple interest. But in MSME matters, compound its interest is the defaulting party is liable to pay the compound interest upon the bank rate which is existing at that period of time.
Okay.
So these are the legislation for governing the delay payments in India in commercial matters.
Okay. And what are the main reasons or common reasons for disputes related to unpaid dues in commercial contracts?
See, basically, it comes with the breach of contract.
Hmm.
If any of the party breaches the terms of the contract, is one of the prime reason. Then comes the ambiguity in the contract terms, like certain words which are unclear or vague, like as soon as possible, or the party will make a reasonable effort. So these are certain ambiguous terms which lead to dispute arising, which arises out of the contract. Third is the payment issue, that is the late payment, or there is a disagreement on the payment, or if there is something on the error in invoices. Then comes the performance issue, like non-performance of obligation to a specific standard, like incomplete work or delay in completing the work. So there are also contract variations, like change in existing terms of the contract. For example, in building contracts or contracts, a person give a contract just for fixing of the doors. Then they also say, we also like to do the fixing in the windows, which also is a reason for dispute that actually happens in the long term contracts. Thereafter, this termination and exit clause, that sometimes party illegally terminate the contract without giving a specific reason for the termination and the exit policies. So these are the common reasons for dispute which arises in a contractual transactions, commercial transactions.
Okay. And what are the legal avenues that businesses have to recover debts or unpaid invoices in India?
So as I discussed earlier, uh, there are specific legislations like
Yeah.
Commercial Courts Act. If there is no arbitration clause in
Hmm.
your agreement, then you can file a commercial suit. Or if you are a MSME concern, if you are registered with a MSME, then you can uh, 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 take your legal actions under MSME Act. And if you have a arbitration agreement, then you can invoke arbitration to recover those dues.
And how effective is mediation as an alternative to litigation in matters of commercial recovery cases?
Yeah, so mediation in the last 2 decades uh, became a boom for the Indian market and in an Indian commercial system. So after outbreak of COVID, thereafter there was lockdowns. So it actually the unprecedented outbreak of COVID and its ramification uh, across various business entities and economy has left the corporates in great turmoil.
Hmm.
So thereafter, since there were multiple disputes arising out of a contract, so it was better for the parties to sit and mediate rather than litigate.
Hmm.
And even as per our CPC and Commercial Courts Act, even in Commercial Courts Act, there is a provision which is Section 12A, that before filing a commercial suit, it is mandatory for the party to file a pre-institution mediation, so that parties before going into litigation sit together and resolve their disputes by mediation. Also, in CPC, as per Section 89, courts encourage parties to go for mediation, and it is very cost effective and efficient. So, mediation uh, plays a significant role in dispute resolution rather than going for even arbitration or litigation.
Okay. And uh, what, according to you, are some of the major challenges that businesses are facing, in terms of litigation matters, or even while trying to recover their unpaid debts, according to you?
Sorry,
So I was asking you about the
can you repeat?
challenges businesses face in recovering dues from defaulters, or in general, in terms of commercial disputes. What, according to you, are the major challenges businesses are facing?
Uh, After, if a decree is passed or an award is passed, the major challenge is the enforcement of the decrees. That once a decree is obtained, they have to file execution. Thereafter, also the defaulting parties try to uh, avoid from their legal liabilities. They file appeal, go into appeal, and thereafter execution is stayed by the court. So these are the challenges. Also, they this uh, they conceal their assets so that the recovery cannot be go ahead.
Hmm.
So these are the problems.
Okay. And
That
what?
is mostly after the awards are passed.
Okay, okay. And then what are the precautions that businesses can take, while maybe say drafting their contracts, to reduce this risk of non-payment? Hello. Yeah, sorry, your
So
network just, I think, is a bit sketchy. You were saying that businesses should do due diligence
yes,
before.
with due diligence before with the contracting party regarding their assets and about their ongoing litigation with any other parties,
Hmm.
and what is their frequency of payment with the other parties or not. So these things a party business concern should uh, uh, verify before entering into a contract. Thereafter, also, while drafting a contract, there has to be a specific clause regarding their breach of contract. In case they breach the terms of the contract, there should be a specific amount mentioned. So, and also in case of the defaulting party has to pay interest at this much rate of interest.
Okay.
So if these things are in their contract, so the courts or arbitral tribunal will pass the award or decree as per the terms of the contract only.
Hello?
Yeah, legal notices. Can you repeat your question? Can you repeat your question?
Yeah, yeah. So you were just saying something in the end, right? That part got cut
Yeah,
out.
hello. Can you repeat your question?
Yeah, I was just saying you were talking
Hello.
about. Hello.
Can you?
Yeah, yeah. I'll repeat the
Yes.
question. I was asking you about legal notices and demand letters then. Do these play an important role in recovering any unpaid
They nowadays they do actually they do as per my practical
yeah.
experience. They does not play a much role in recovery
Okay.
because legal notices or demand notices set the civil liability in motion that the other party may file a suit or invoke the arbitration, but that does not play much role. People just ignore legal notices and demand notices or just file their reply,
Okay.
taking their stand.
Okay. Okay. So it's not that effective when it comes to trying to recover any payments or anything like that.
They do not play much role. Yeah, it is not that.
Okay, okay. And according to you, what are the necessary reforms or what is necessary to be changes to be made in India for, more efficient and business friendly practices so that such defaults, such disputes are not happening?
As in legal reforms, are you talking
Yes,
about, or
yes.
in as in general?
I mean, you can answer
So
it in
far
both
as,
ways.
see, just to that a party should not get into uh, legal trouble or disputes, or for to avoid the delay in payments, the first very thing is the contract has to be watertight and
Hmm.
very specific about the terms of payment, that the payment shall be made within within a specific period of time after the goods are received or the services are availed. Thereafter, there should be a clause regarding the interest part, or uh, or the awards which has to, the amount which they have to pay in case of breaches. As far as legal aspect is regarding, we have a lot of amendments in Arbitration Act for the ease of business, that as per amendment in 2015 and 19, the Arbitration Act Section 8 and 9 provides for mandates the judicial authorities to recommend parties for arbitration if there is an arbitration clause. And in case an interim order is passed, uh, the arbitration has to be initiated within a period of 90 days. Thereafter, also, the entire duration of arbitration proceeding is also there, that after within 6 months, the statement of claim and statement of defense has to be filed from the date the arbitrator is appointed. And after the pleadings are completed, within a period of uh, uh, 12 months, the award has to be passed, which can be extended with consent of parties for 6 months. And even in that period, the award is not passed, then the extension may be taken from the court. But in the meantime, the mandate of arbitrator will not terminate, it will be there only. The next important thing is also regarding the this execution of the uh, arbitral awards. So prior to 2015-19 amendment, if a Section 34 petition is filed, that is for the setting aside of the award, the execution is automatically stayed. But now there is conditional stay over the execution. That is, mean ki the party who is challenging the award has to deposit certain amount of the award, or the entire amount of award before the court to seek the stay. Then there is also the judicial interference is also limited, that the judicial authority may interfere with the award which has been passed only upon the basis of the arbitral award, on the records of the arbitration, and not go beyond that, which was in 1996, this act. So this thereafter we have Commercial Courts Act, like I said.
Yeah,
But the biggest challenge is the implementation of the Commercial Court Act in a true sense.
right.
Still, we don't have a proper infrastructure in courts for implementation of the, since Commercial Courts Act provide constitution of special courts, special commercial courts, which will deal with only commercial disputes. So that is also a challenge which courts are facing, not in metro cities but in other states like Bihar, Jharkhand, MP, and all these states. These are the problems. Therefore, also thereafter also we need more judicial officers with who are efficient in functioning of the commercial courts. So these are the reforms which are necessary for the proper implementation of the law. which could make the recovery process more efficient and business friendly.
Right. So I think with that, we've answered and covered most aspects of today's topic. Is there
Yeah.
anything that you would like to add before we end today's podcast?
This is the last thing which I had added.
Okay, great.
The
Um, I mean, a huge thank you to you, Advocate Piyush, for sharing your valuable expertise in breaking down these complex legal, matters. If you or your business is facing any disputes, don't wait. Explore your legal options and take action. I think this was a really insightful discussion. And recovering dues in commercial matters can feel like an uphill battle. But as we learned today, that the law provides us with multiple avenues to ensure rightful payments. So, if you found this episode helpful, be sure to share it, subscribe, and stay tuned for more discussions on legal insights that matter. Until next time, stay informed and stay protected. Thank you so much.